These are part-heard appeals in the matter of DSM IP assets in another and Algal omega-3 and Mara Renewables.
My Lord, unless
you reflected?
Yes, unless you've got any more questions, we've completed our submissions.
No. Thank you very much. Can I just deal with the email we've been sent about the proposed text of the draft order? The text is approved, but could you draft an order?
Of course.
Please, and send it to us. Thanks very much. Yes.
My Lords, before I move on to 801, can I just raise a couple of issues by way of reply on 155?
Yes.
The first is this. The theme of my friend's submission was that I was somehow pivoting to a new case by accepting the judge's finding as to the skilled team doing one of the examples in bile. And he drew attention to the fact that our case suggested, at trial that was, that the skilled team having a fear of emulsions would go directly to enzymatic lysis. So the difference is simply this: go to enzymatic lysis because of a perception without doing the example, or do the example and go to enzymatic lysis when the fear is confirmed. And there's nothing in the point in my submission, and certainly not something that the judge considered significant. I obviously have to live with the judge's evaluation on whether the example is tried first or not. My appeal is directed to that scenario. The question of whether it's an obvious thing to do to use enzymatic lysis in that scenario. In the judge's analysis, so on the basis that an example is carried out, he held the issue finely balanced. And it's clear he held against me because he considered the suggestion that enzymes would be adopted was hindsight without a reason to do it, and specifically proceeded on the basis that there was no evidence that a skilled person reading bile would see the difference between homogenizer and enzyme-generated emulsions. It's clear that was key to the judge in his scenario, and if I'm correct in my submissions about him actually overlooking that which he identified as being needed, I'm correct, and I'm entitled to succeed. It doesn't have to be the most obvious thing to do or the first thing you do, and so it really is a point of no significance in my submission. It's just I'm facing up to the reality that I have to live in the world where the judge's analysis as to whether you do an example or not applies, and it's not a significantly different case, and the judge certainly considered the obvious argument finely balanced in that scenario. Can I move on to the second point that I wanted to just respond on? My friend sought to unpick that paragraph 314 and say that it contains two separate things. Firstly, the appreciation of the emulsion problem being caused by the violence of mechanical lysis that's not present in enzymatic lysis, so it would produce a gentler emulsion. That on the one hand, and quite separately, he says, the thought process pointing the skilled team towards taking up enzymatic lysis. And as I've understood the submission, he says paragraph 314 is defensible on the basis that there was evidence as to the first, but it was absent as to that separate assertion, an assertion by an expert, as I understand what he's suggesting, as to the thought process. That, in my submission, is a completely artificial way to read that paragraph. And if it was what the judge meant, he wouldn't have granted permission when this error was drawn to his attention. And what I say to my lords is one can see what the judge is getting at when one looks at paragraph 316 in addition. He wants a reason. And as my Lord Justice Arnold knows, reasons are what matters most in many patent actions, and the judge wants a reason why the skilled team would focus on enzymatic lysis. And it is the appreciation that enzymatic lysis emulsions would not have the same exacerbated emulsion problem as homogenizer-generated emulsions is the reason. He thought there was no evidence, and we've been over why he was wrong about that. In any event, my lords, that passage of cross-examination of Dr. Wynne did go on and deal with the thought process. that enzymatic lysis would be better, which my lords will recall he accepted, of course subject to the qualification he gave as to whether you could get an enzyme system to work. But on that issue, the judge held, on that particular qualification, there was no problem in identifying a suitable enzyme. So that's the second point. The third point is that my friend sought to deal with the issue that my point that saying that homogenizer exacerbates the problem is the same as saying there's a weaker emulsion with enzymes, by saying that there was no evidence the skilled team would realise it was much weaker or significantly weaker, or that the difference between them would make a difference to the emulsion. And he rather jumped on a point that my Lord Justice Miles put to him about there being a thick mayonnaise and a mayonnaise that's a bit thicker. The issue, my lords, with that line of argument is that it involves accepting a view that my friend's own experts identified a point in their written evidence, the worry about it being particularly acute, exacerbated, to use Dr. Wynn's language, to use the violent homogenation, when really the skilled team would perceive it as to be a difference which was insignificant. So it's just not realistic in my submission. His experts identified a point, to think that they were identifying a point that they actually would suggest nobody would think had any significance. Of course, it's not necessary to know for sure it will definitely work with enzymes, just that the emulsion will be weaker in a way where it's likely significant on that issue. So those are the 3 points I wanted to pick up on reply to my friend's 155 submissions. If I may, I'm going to turn to 801 and go straight to ground 1A, which is the construction issue. My lords have seen the claim, and in particular the words that we're arguing already, but can I just remind my lords of it? You need the supplementary bundle 1, and it's at the back of tab 2 in that file. So I'm on page 122 of the bundle, and we're looking at the top half of the page, claim 1A. And one can see the structure of the claim is a process claim, as the introductory words explain, a process for obtaining a lipid from a microbial cell. So it's a process that results in a lipid, and that lipid comes from a microbial cell. And it's structured by identifying 4 steps that the process must comprise. The wording of the claim is comprising, so it covers all processes that have these steps, even if other steps are also included. That's a convention in patent language, and it's common ground. Now let's look at the 4 steps. First, lysing a cell to form a lysed cell composition. Second, adding a base to the lysed cell composition, raising the pH of the lysed cell composition to 8 or above to demulsify the cell composition. Step 3 is one or more of 4 different steps to demulsify the cell composition. One simply has to do one or more of them. And in each case, it's doing something or adding something to the lysed cell composition. So we have salt, you know how that assists, that's C1, heating, C2, agitating, so stirring, that's C3, or adding a second base. So one or more of those. And the 4th step the claim requires is separating a lipid from the demulsified cell composition. And hence one then has the lipid that the introductory words say the process is for obtaining. Now there are 2 further clauses added to the end of the claim, each beginning with the word wherein. And that's patent speak for an additional limitation to the claim or part of the claim. And can I just address the second first, the one in red? It's proposed to be added by amendment. It relates to the lysing step. That must comprise, so must include, enzymatic treatment. And it was simply taking one of the additional...
Can you just help me, just so as I'm clear, what's the status of the amendment? I assume, but correct me if I'm wrong, that the amendment was not allowed on the basis it didn't say validity.
Exactly.
But if the claim would have been valid, I take it that the amendment was held allowable.
But there was no objection, so
Yeah.
yes, we argued it on the basis of this, but my Lord's right, formally it was not allowed because it didn't save it.
Yeah.
That's exactly it. I think it was just claim 10, a subsidiary claim, that they were bringing that limitation up from. I'll be corrected if I'm wrong. So it was narrowing.
It's part of claim 10.
Yeah. And the first of those additional clauses in the black, it's in black because it was wording already in the claim as granted, states wherein the lipid contains less than 5% by weight of an organic solvent. And my Lords know that. It's the words of that clause that we're arguing over. Okay. Before I look at the disclosure of the patent in the specification, can I draw attention to a couple of features of this claim? The
Do you
first,
mind if I just ask a question
not at all.
about those words in red?
Yeah.
I think you said just now that it's a convention of the drafting of claims that the word comprising means including, but it could involve other
Yeah.
steps.
Comprising.
So does that mean that the bit at the end could cover a case where there is both enzymatic treatment and mechanical treatment?
If the lysis is affected by the two in combination, yes. That's why I said it includes. I think I did say it. My note certainly intended to do that. Yes, is my answer.
Right. Thank you.
I don't think anything turns on it.
No, I'm just trying to
but
think through the consequences.
the answer is yes. The first point I make about these claims is we've got 4 steps set out, but we've got quite generalising at the top. Obviously, the wherein requires it to include enzymatic. But the detail is really in the combination of steps B and C. So adding a base to raise the pH above 8 and doing at least one of the things identified in C.
Sorry, to go back to the amendment. Of course, what I said earlier is rubbish because it wasn't held invalid. That's the issue. So I assume, therefore, the amendment was actually allowed.
It was held invalid, my lord, because the proper construction meant
So
that
we're on 801 now?
Yes.
Yeah. Sorry. So I was right first time. Thank you.
Yes. And the point that I'm just trying to make to my lords is that the essence of the detail is really in steps B and C. And what that is the combination of step B, the raising of the pH, and then doing something, one or more of those step C things. The second point I want to draw attention to is that it was DSM's case, and I think actually it's common ground, and at any rate the judge accepted, that step B did not need to actually achieve demulsification without other steps being taken. The same is true of step C. The submission was the claim is satisfied if step B and at least one of step C to C1 to 4 together contribute to demulsification in a material way. And my lords can see that set out in paragraph 764, both that it was my friend's position, reference to it being common ground, and the judge saying in any event he agreed with it. It's on page 287 of the bundle, behind tab 12, towards the bottom, just under the bottom hole punch, 764. And I do invite my lords to note this, because I think yesterday my friend suggested demulsification was achieved only by steps B and C. And he obviously wants to do that for the argument that he's running on construction. But there was no appeal from 764, nor could there be, as it was his position. And let me spell out the consequences of that. That means the claim is satisfied if the process has other steps that contribute to demulsification, as long as the claim steps are present. Demulsification is achieved, and those claim steps have contributed in a material way. The third point I draw attention to on the claim is the fact that the precursor to the, quotes, the lipid in the clause we're concerned with is in the words a lipid in the introductory words, the thing the process as a whole is for obtaining. And then again you see it in the final step D, that is where it is being separated from the demulsified cell composition, the lipid. And my lords obviously have my submission that this is the lipid being referred to in the words in issue. I also draw attention to the fact that the skilled reader would see that the patentee has well in mind in this claim the difference between the lipid which emerges at the end and the lyse cell composition during the process. And I specifically draw my lord's attention to the fact that there is repeated reference to the latter, and it is deliberately using different language, either using the longer form lyse cell composition or the shorter form simply cell composition. I say repeated reference, it could not be more prevalent. One sees it in step A, lyse cell composition, twice in step B. One is the fuller lyse cell composition, the other is the shorter cell composition. And similarly, twice in each of C1 to C4. There is absolutely no doubt the patentee is distinguishing between the lipid, that is the end product of the process, and the lyse cell composition from which it's obtained. Moreover, I'd further draw attention to the fact that when a step is being carried out during the process, where all we have is the cell composition, the mixture of everything, not only does the claim take care to refer to the cell composition or lyse cell composition, if that's the state it will be in, we see at claim 3A a reference to a percentage by weight. This is as to quantities of salt to be added. And again, we see consistency. It's given as a range of percentage by weight of the lyse cell composition. Of course, my lords know I have a point that it makes no sense to talk about the lipid containing less than 5% weight of organic solvent before it's been recovered, because you'd never know how to operate it. I've got that point, but the point I'm making here is that you can see that when actually it's talking about a fraction of something in that earlier stage, it is talking about the percentage of lyse cell composition. My lords, the final point I want to draw attention to on the claim is a point one does not actually see here on page 122 of the bundle, where the auxiliary request has been typed out. Here we see the individual steps C have been indented, but all the other steps and the introductory words are all the same. Can my lords turn back to page 112, please? So the claim as it currently exists, so without the proposed amendment in red, but this is the claim in the granted patent. And what we have here is the introductory text telling us that the process is for obtaining a lipid, etc. Then after the words said process comprising, all of the steps are indented. Those at C are further indented. And then returning to non-indented text, we have the words we're in dispute over, the wherein the lipid words. And my lords, I don't want to overplay this point, but it is, I submit, reinforcing of what one sees naturally anyway from the language, however it's laid out. But it's reinforcing that the lipid being referred to in that last clause is talking about the lipid referred to in the first line, the two lines that are not indented at all, the product of the process. Now, my lords, can I turn to the disclosure in the specification and the aspects of it, both that I rely upon and those parts that my friend is particularly keen on. And before I look at any particular text, can I ask my lords to have a couple of points in mind as we do this? The first is that the patentee will typically have more than one purpose in mind in a disclosure. An obvious example may be that they intend to describe a process and its characteristics. They may also intend to describe characteristics of the product obtained. And one has to be careful to understand which language relates to different purposes. And of course, not everything put in the disclosure is then subject to the claims, whether that be because the patentee pursued other aspects in divisionals, or just because they were not pursued for whatever reason. The second point that I invite my lords to have very clearly in mind is to understand the difference between an invention that enables a particular thing to be achieved and one which requires it to be done that way. My submission is there's a difference between recognising a technical contribution and a particular advantage that can be achieved by using it, what can be achieved by using it is not the same as the technical contribution itself. Put more bluntly, one can see the disclosure of a new process, a new combination here, that's a combination of putting the pH to 8 or above plus one or more of the steps in C, contributing to breaking the emulsion, contributing, that's what it was common ground it had to do, but no more. That could be a contribution in a patent sense, and people can argue about whether it's inventive or not. But what is clear is that contribution may be used both absent any solvent and in conjunction with a solvent. In both cases, one is using the contribution of the new combination, pH, say, and salt, to contribute to dealing with the emulsion. And it may be that it can enable solvents to be avoided. But that is not the same as saying one cannot be using it unless you also avoid the use of solvents. And my lords will see 801 does very clearly identify achieving solventless extraction as an advantage that can be achieved, but in fact only describes it in a way that some embodiments don't utilise solvents in an amount or concentration sufficient to extract a lipid, even in my friend's favourite bits. And the series of points that I've just made to my lords are all reasons why one mustn't forget the language of the claims. So with those points made, can we begin at the beginning of the document? You'll have seen that its title is Extraction of Lipid from Cells and Products Therefrom. That's the title on page 14. And as soon as we turn over into the main text on page 15 of the bundle, we start with one of my friend's big points.
Well done.
Sorry, it's tab 2.
Yeah.
It's the same page 15 of the bundle. Yeah,
Okay.
Yeah. Got
Page
it?
15.
Yeah. So I've just turned over and this is the beginning of the main text.
Yeah.
And this is one of my friend's big points. I think it's paragraph 19 of his skeleton, refers to paragraphs 2 to 5, particularly 5. Paragraph 2 sets out at a very high level a process which uses hexane. Paragraph 3 is directed to isopropanol, so that's the Freelex thing. 4 is directed to the consequence of using solvents, and 5 says there's a need for a process for obtaining lipids that does not use an organic solvent, before then referring to previous proposals. And it's that sentence that identifies the need that my friend picks out in his skeleton, paragraph 19, saying that's the problem 801 solves. And of course, I'd put it another way. His patent discloses a combination of process steps that contribute to dealing with an emulsion and may be deployed in a way that enables the use of solvents to be avoided. But one is still using his process if one does not use it to achieve that advantage for whatever reason. In fact, one gets a hint of that in my friend's next paragraph. He says his combination, the method comprising his 2 steps, achieved demulsified cell composition, that's his paragraph 20, without requiring an organic solvent. Not requiring one is not the same as positively requiring there be none, as I've explained. Now, before we get to my friend's really favourite bit, paragraph 86, can we look at some disclosures in the brief summary of the invention? So starting at the foot of page 15 of the bundle, so I'm on the same page, we see there that consistory clause, paragraph 7, and after that we see a series of paragraphs starting at 8 to particular features that some embodiments may have. So on bundle page 16, we see them directed to processes or some aspect of it. So, as is typical in a patent disclosure, we've got a series of things that some embodiments may have, implicitly, not necessarily all of them. And right at the bottom of the page, paragraph 27 tells us that in some embodiments, the process provides a lipid with a particular makeup. It's a certain level, 50% of triglycerides. That's the molecule where you've got glycerol with 3 fatty acids hanging off it. But the point I'm making, to my lords, at this point, it's moved attention to the property of the lipid one gets from the process. And my friend accepted yesterday some paragraphs of this document are clearly directed to the lipid end product. I think he accepted it in relation to 52, said there were others. My lords, there are loads of them. And 27 is just one. Over the page, so page 17, it continues in a similar vein. First, directed to the anisodine value of the lipids obtained, that's 28. Paragraph 29 is peroxide value, phosphorus content, and so on. It's paragraph 32 where we revert to identifying process features present in some embodiments. Paragraph 38 is important. We really should have drawn specific attention to it in our skeleton. I'm sorry we didn't. Perhaps my lords would add a note in manuscript to our skeleton, paragraph 18, to also note paragraph 38. that paragraph explicitly says the disclosure is also directed to a lipid obtained by any of the processes. And my lords, I hope realise that is the essence of my argument.
Well, now we get into real patent nerd territory. So, it says the present disclosure.
Yeah.
It doesn't say embodiments. Now, that difference in language may be deliberate, because one of the techniques that is sometimes employed in patent drafting, particularly where you've had a limitation in the scope of the claim during the course of prosecution, is you distinguish between what is disclosed in the specification but is not within the scope of the claims, and that which is within the scope of the claims. So when it says the present disclosure, not necessarily what's claimed.
Well, you'll see it becomes, you get it more and more. It's not the only instance, my lord. So I do understand the point that you're making to me. Actually, the essence of my friend's case is that the disclosure of the text of the specification is such that you would understand it is telling you you mustn't use solvents. That is the essence of his argument. And when we get further into the details, you'll see that it is plainly contemplating the embodiments being the lipid and talking about the lipid. But I do understand the point that your lordship makes, that in a different context, you might see the kind of distinction being drawn that my lord puts to me, but not here in my submission.
Well, can I just test that a little further? Why not? Because what we can see is that in this document, the draftsperson is certainly distinguishing between disclosure and embodiments.
Look at 44, for instance. I'm just going to get there in a minute, but 44 is talking about in some embodiments the lipid is a crude lipid, and then it actually...
To be sure, but then your point on 44 stands on its own merits.
It does. But what I'm saying to my lord is...
The question is whether you get anything more out of 38. Having told us it was important.
Well, maybe I shouldn't have done that. Maybe we're right not to rely on it. My lord, there is so much of the individual paragraphs like 44. When you see the whole of it, and then 38 is just telling you generally we're concerned about lipids as well.
Okay.
The reason I drew attention to 38 was it was just a one-sentence thing basically saying we're worried about lipids, but you see it again and again. And the series of paragraphs actually following that are more paragraphs directed to the lipids. So this is introductory to these paragraphs, and all of those are talking about in some embodiments, my lord. So that's why I accept that it's a possibility in a different case, the point you put to me. It's not what's going on here. And of particular note is 44, that I jumped ahead to just a minute ago. Some embodiments, the lipid is a crude lipid. Crude means it's just not been subject to some of these further processing steps, which was actually the subject of the other patent. So there's things like winterization that my lords haven't been troubled with, but it's basically the lipid that you get from separation. So in some embodiments, it's the lipid as a crude lipid, and the second sentence adds a further possibility. Crude lipid optionally has less than 5% by weight of organic solvent. The very words that we're concerned with, here being used as a characteristic, optional at this point of the disclosure, but a characteristic of the lipid that results from the process.
I don't know whether it has any significance at all, but just in relation to the point that my Lord Justice Arnold made, I noticed that the next paragraph talks about the present disclosure, but it also has those same words at the end of it. Because it goes back to options with less than 5%.
I think that reinforces the point.
But I don't know whether that does or does not have
Well,
any significance.
my submission is it's quite plain that when it talks about the disclosure at 38, it's definitely not trying to make the kind of distinction that my Lord Justice Arnold identified as the kind of thing that sometimes happens when you're not claiming something, because it's basically introductory to in some embodiments. And the point that my Lord has just made, I think, just reinforces that it's not trying to do that, because it actually mixes them up in, I think, 45. The point about 44 is that it's very similar to 52 that we did rely on and my friend accepted, is to the end product. There, of course, the same words are in, but it's not an optional feature. So you've got the 5% by weight or volume of organic solvent there as well. And in fact, my lords, as far as I could see, all of the paragraphs between 44 and 52 are further paragraphs directed to the characteristics of the lipid. So my submission is that the disclosure is clearly directed to both the lipid that results from the process and the process. And my submission is that the reader would see that and appreciate the patentee was aware of the difference and capable of distinguishing. Now, if we move to the detailed description of the invention, which starts at the foot of bundle page 18, we have another consistory clause, that's paragraph 56, and then there are a series of paragraphs 57 to 60, which we drew attention to in our skeleton, at paragraph 18, I think, as the examples of disclosure plainly directed to both the process and the resulting lipid. And the difference here between these paragraphs is the different demulsifying steps, but each has wording at the end that the lipid optionally contains less than 5% by weight or volume of an organic solvent. Here it's just an option. And I do actually pause at this point and make a point that if, as is the thrust of my friend's case, that the language of the disclosure is intended to understand quite generally to say that you mustn't have more than 5% in the mixture throughout, why does it say it's just optional? Of course, the actual requirement in the lipid to be 5% has been the limit that's been imposed in the claim. But the point I'm making is the thrust of my friend's argument is you'd understand the whole of this disclosure as eschewing any level of lipid in the mixture at any point.
Well, I wonder how far you can take that point, because you might have disclosure in the specification of options, but then the claim makes them compulsory.
Exactly, and I totally understand that, so we've got all sorts of other limits in there as well. The point that I'm making is really the guts of my friend's submission is because, for instance, the reliance on the early part, the fact that it provides you with something that enables you to avoid solvents. Really, the thrust of his submission is that if you read the whole disclosure together, you know that they're telling you must never have more than 5% solvent present at any point. And I totally take the point that my lord's putting to me, that obviously the claim itself will possibly limit to things which are expressed as optional in the disclosure. But what I'm saying to you is that insofar as he's relying on the overall thrust of the disclosure, this is a point against him, because it wouldn't have been included at all. So we've got these paragraphs 57 through to 60. And while we're looking at those, you
Can
can...
I just ask while we're here
Yes.
on a completely different question, which I suspect is entirely irrelevant. But one of the oddities is that when one looks at these paragraphs, and they're not the only ones because we've seen it elsewhere, it's less than 5% by weight or volume of an organic solvent, whereas the claim is restricted to 5% by weight.
Yeah.
Do we get any assistance from that either way?
In most cases not, because strictly that's just a sub-option.
Yes.
So you could, and it might make a difference depending upon different densities, obviously, but you don't where you see something where both are. I'm going to come to a point where it's just by volume, and you do get something from that because it can't be the thing that the claim is referring to.
Okay.
But where you've got something where the language of both is, my friend would just say, well, all I've done is pick one of the two options that are actually being put forward in the language that says one or the other.
Yeah.
So generally not, but in one case, yes. The point that I was making to my lords is that while we're here, you can contrast what's happening in 57 through to 60 with paragraph 62, which simply addresses a process identifying its features without saying anything at all about the lipid that results. Or indeed the thing that my friend is asking to be read in to absolutely everything in this document, a limitation such that there must be an absence of organic solvent throughout in all cases. Now, my lords, the series of paragraphs from 62 are back to process details as regards some embodiments. And that's the case right through to paragraph 74, which is back to the property of the resulting lipid. In some embodiments, the process provides a lipid, and so forth. Paragraph 75 expressly mentions that in some embodiments the process does not add an organic solvent to the lyse cell composition. Patent disclosure is saying this can be achieved, but it's not saying it must happen. In some embodiments are the words used. That can only mean one thing. In other embodiments, the opposite. And also the rest of the section from paragraph 77 onwards contain another series of paragraphs stating the disclosure is also directed to lipids, identifying various characteristics of them, paragraph 80 is about the crude microbial lipid, for example. If you want one that begins in some embodiments instead of the present invention, you can go up to 78 and 79. It's all of a piece. It is concerned with the lipid as much as the process. We now come to paragraph 86, which is the paragraph my friend looks at in his skeleton and spent some time on. I've got to be a little bit careful with my friend's skeleton, paragraph 22, as to how he's extracted the text to run together and quote here. He did it off the document, which I'm going to do as well. And he did it sentence by sentence. The first point I make about this is the first of two paragraphs under a heading overview. So he's giving an overview, and there is not much more that follows in the detail after the overview before you get into the fine detail of the specific examples, which start at paragraph 205. Paragraph 86 itself says in the first sentence, generally, the processes, do not utilise an organic solvent in order to extract or otherwise separate a lipid. So not just don't use it, but don't use it for that purpose. And it's just put as generally, not something that it's done to extract or separate the lipid. And you have to read this with the next sentence because that begins thus. So it's obviously to be read with what's just gone. It's a consequence of the first sentence. Thus, in some embodiments, an organic solvent is not added to a cell broth comprising plant material, fermentation broth comprising a microbial cell, not added to a cell composition, not added to a live cell composition, is not added to a lipid during a process of the present invention in an amount or concentration sufficient to extract a lipid. My friend said these 5 things identified here are in effect at every stage, so everything that a solvent could be added to. I'm not going to quibble with that. My friend accepted these 2 sentences were not good enough for his case. Because it's just a general thing and the wording says in some embodiments. I go further than that. It's obviously not good enough. It's in fact worse, it's against him. It's against him because the language about what is generally not to be done, and that's what occurs in some embodiments, is expressly contemplating that it may sometimes be otherwise in the other embodiments. And let me be absolutely clear. It identifies a whole series of things which may exist at different times, which my friend says is everything it could be in the process, from the broth right through to the lipid. And it's saying thus, in some embodiments, an organic solvent is not added to the mixture at those stages in an amount or concentration sufficient to extract lipid. And it is very important that my lords grasp that the others, so not subject to the wording some embodiments, the other embodiments, not subject to this sentence, it will be or might be added in an amount sufficient to extract a lipid. Now reading on, I'm now at line 3 of the bundle. Some embodiments an organic solvent can be added to a cell composition, live cell composition or demulsified cell composition. So here it's actually only dealing with 3 of those 5 things, not everything. And it's indicating that it might be added, and it would only be a small component because it goes on to say in such embodiments the organic solvent is added in a concentration less than 5% and various reducing limits. So these 2 sentences obviously go together, and they are addressing embodiments where solvent is added in those low percentages, a list of 5% or lower right down to 0.05%. My lords, those are obviously not the embodiments where organic solvent is or might be added in amounts or concentrations sufficient to extract a lipid. Not saying anything about those that were recognised in the first and second sentences. Further, if you go to the end of the sentence and note the lowest alternative in the list, the words after, which obviously qualify each in the list, is by volume, not by weight. And this is the point where it does matter, my lord. My friend sought to brush that aside by saying later it referred to weight or volume as if that means one can read it in here. Patents notoriously contain endlessly similar disclosures with only small differences in language. And here, these reducing limits are by volume, and moreover plainly by volume of the cell composition, live cell composition, or demulsified cell composition that are expressly identified as the thing to which the solvent may be added. This is nothing to do with a percentage by weight of the lipid. My lords, as you saw yesterday, the paragraph then diverts to explain in some detail what's meant by organic solvent, and we can pick it up after that diversion. So there's more text, rather repeating some of what's been said. And we can pick it up at line 13, where I think my friend picked it up. An organic solvent, as defined herein, can be optionally added to a lyse cell composition. So just one thing here, not all five. For example, as a component of a base and or a salt contacting the lyse cell composition. And it goes on, however, in such embodiments, the organic solvent is present in concentration such that the lipid is not substantially extracted from the cell composition, lyse cell composition, or demulsified cell composition by the solvent. So it's telling the reader about something specific that might be wanted to be done, where you could still do it without adding it in a concentration sufficient to affect extraction. And the text has parentheses saying, i.e., although the sense is such that perhaps the EG might be really what's meant, but it's giving you the concentrations that may be appropriate. But one thing we do know for sure is it's not referring to those embodiments recognised in the first two sentences as a possibility, embodiments where the solvent is or might be added in quantities sufficient to extract a lipid. And again, I pause and make a similar point to the one I made on the text above the intervention. You've got limits here that now say by volume or by weight. But either way, this is not anything to do with the claim limitation. It's still a percentage of the thing to which the solvent is added, not the lipid. Well, also there's more I need to show you, if I may, in the rest of this section before the document gets to specific examples. And the overarching point I make is that the document continues to go between disclosures pertaining to a process and characteristics of the lipids obtained in some embodiments. And I obviously can't pick out every paragraph nor even every change, but I would just highlight the following. The heading processes at the foot of bundle page 24, which I think my friend went to and dwelt on a little. In this section, paragraph 120 on bundle page 26 recognises that the processes of the invention will not necessarily adequately deal with all of the emulsion. It claims that in some embodiments, so not even all are covered here, some might be worse, but in some embodiments, varying proportions of the emulsion starting at 5% will be broken. So this is recognising there will be room for significant improvement in some embodiments being referred to, perhaps even greater improvement in the others. And what I mean by that is that if you deploy other techniques consistent with the claim construction, there's room for improvement. But my friend's case is the pattern is not intended to cover embodiments where you have boosted the percentage, for example, by adding some isopropanol. The next thing to pick up in this very long section is that there is a contrasting subheading, microbial lipids, at the foot of bundle page 34. So really emphasising that the document is concerned both with processes and the lipids. Don't think my friend showed you this. At this point, it's obviously specifically focusing on the characteristics of the lipids that are obtained by the processes of the disclosure, as the first sentence of para 178 indicates. And this actually says in some embodiments the present disclosure is. In fact, my lords, the document goes on and is even more specific at this point and includes standalone sections on lipids obtained in some embodiments from two different classes of microorganism. You'll see the heading on bundle page 35 at the top, lipids extracted from a first set of isolated Thraustochitrid microorganisms. This whole section is directed to properties of those lipids. Similarly, bundle page 37, just below the top hole, there's the heading for the second set of Thraustochitrids. All these paragraphs down to paragraph 201 directed to lipids obtained, end product lipids obtained from those microorganisms. Can I just pick up a couple of points? Actually, it's the same point in each of these sections. So the general description, so back to microbial lipids at 178, text is plainly directed to the properties of the crude microbial oil extracted according to the processes, and different aspects of that end product are being described through this paragraph. Look at line 54. What we're arguing about. That's another thing we really should have flagged up in our skeleton. I'm sorry we didn't, but please note it. The language plainly directed to the product of the process in terms of the limit that we're concerned with. Less than 5% is a list of different limits, but the less than 5%, by weight or volume, they've gone for weight in the claim as an organic solvent. So they picked out 5, they picked out weight, and they're in the claim. And in this context, it obviously is by weight of the lipid. And there's a similar statement in the section on the first set of isolated Thraustochitrids, so paragraph 189, page 37, they're quite long paragraphs, page 37, around about where the top hole punch is, line 17. There it is again. Just to really ram home the point in the second set, paragraph 201. I'm at line 55 on page 39. Now, my friend refers to the specific examples not utilising organic solvent, or at least not doing it, say, for an analytical step in example A. I don't make anything of that. What I do say, unfortunately for my friend, is that that does not really assist his argument. It's one of those points that only really works one way, where there's an inconsistency that you can rely upon. The fact that something's not there doesn't mean that the general disclosure of what may be done in some embodiments is not in the rest of the general disclosure. So as I say, it's no more than drawing attention to the fact that I don't also have an absolute knockout point on the specific examples. It doesn't help to say that really in my submission. My Lords, my friend also seeks to make something out of the fact that the patent includes a comparison as to yield against a process using hexanal free legs. That doesn't help either. The comparison methods didn't use the 801 combination at all. My argument is the claims don't exclude the presence of solvent during the process. For example, moderate levels of isopropanol to aid separation, which also employs the patented method steps, which contribute to demulsification. The comparison my friend relies upon are not in the claim on my construction because they don't use the method steps. There are yet further problems with my friend's construction. He doesn't really grapple with the issue as to the limit we're concerned with being that the quantity of solvent must be less than 5% by weight of the lipid itself. In fact, it wasn't until yesterday when he was on his feet and he said it orally that did we even know he accepted it was 5% by weight of the lipid. There are two related points. First, he's relying upon passages in the patent, most notably paragraph 86, where the limit being referred to is different. It's obviously not a percentage of the lipid, but the whole composition. And he ignores the passages in the patent I've shown you, several directed to the solvent content of the produced lipid, where we see, for example, the optional feature of 5% by weight of the lipid, which we now has been adopted in the claim. Now, both are 5%, but my lords, please don't overlook that 5% by volume or weight of the whole composition is way higher than 5% of the lipid. So if the solvent stays with the oil, as other parts of the cell composition were removed, those bits that relate to 5% of the composition would be way more than 5% of the lipid. They're just different, these limits. They both use 5% in the list, but they're 5% of different things. And if you think about it, 5% of the composition, like I say, if it stays with the lipid, is way more than 5% of the lipid. My lords, there are two related points which we make in paragraph 31 and 33 of our skeleton. I think you probably have them well in mind already, but just to make sure. The first is it doesn't make any sense to refer to the lipid containing an amount of organic solvent when there is no lipid, just a complex mixture of which the lipid is part. And the second, our paragraph 32 and 33, is how do you even work the invention, follow the instructions, as it were. It's plain the limit we're arguing about is 5% by weight of the lipid, accepted by my friend now. But that can't be known or measurable during the process. We give as an example the point of lysis, but it could be any point. One could specify a limit as a percentage of the lye cell composition, as we've seen. But how, seeking to follow this instruction, could you do it when it's by reference to the lipid? And my friend yesterday tried to argue this second point was not impossible and sought to rely upon paragraph 167 and 168 together with the table on page 56, the FAME analysis. But my lords, that work is done on crude oil after you've separated it. Paragraph 274 just above the table makes clear. And what it's directed to is an analysis of the proportion of different fatty acids in the lipids. And just to be clear, they're not floating around on their own. Some of them will be, or many of them will be as triglycerides. So that's the molecule I mentioned earlier with glycerol with 3 hanging off. If you see something, the acronym TAG or tag fraction, that's what that's referring to. But that FAME analysis has nothing to do with what we've been arguing about. It's about working out how many fatty acids of different types are in your crude oil that you've separated. It's just a different thing. One final point I should address is the suggestion that the experts gave relevant evidence that sheds light on construction. And my friend showed you some extracts of written reports, in particular Mr. Dwepen, I think. Now, obviously the first point I make is construction isn't for the experts. But in any event, what he showed you didn't go anywhere near far enough for my friend. For example, he showed you, Mr. Dwepen, I think at supplementary bundle 1, tab 7, page 218, paragraph 183. The thrust of this evidence is simply that it was clear to Mr. Dwepen, so it's his view, that 801 is seeking to avoid using organic solvent. And that is certainly a major part of it. Something that the combination of process steps may enable one to achieve. That doesn't mean as a matter of construction the document is purporting to describe that combination which will aid demulsifying and abandon all uses of it unless the demulsification is only achieved by that combination. And that's why I showed you what the common ground on the construction was. Or even abandon all uses of it if it's not in part aided by a solvent. And also the upshot of all of this is the judge was absolutely right on construction. The wording we were concerned with, or are concerned with, is directed to a characteristic of the lipid obtained by the process. This is not the case of some inapt language being used to impose a limit on the solvent content of the whole composition throughout the process. That's all I was going to say on the construction argument, unless my lords have any questions for me on it.
No, thank you.
Can I turn to the second validity ground then, which is the attack on the judge's evaluative conclusion on obviousness? And here, obviously, we're assuming my friend's favour on construction. Now, the judge went on to deal with matters in the judgment on the basis he was wrong either on construction points or on points on Kobzev's disclosure. That's on paragraph 851 in the judgment. So that's core bundle, tab 12, page 301. So the first point I make is this is a contingent part of the judgment and being undertaken in case of one of those scenarios. And to do this, he identified my client's case in a series of paragraphs at 855 to 868. They all relate to the obviousness case over COBSEF and features relevant to the claims that were in issue. And the case in a nutshell, just to remind my lords, was that implementing COBSEF in an obvious way, the pH would in fact be at 8 or above because of the protease alkalase. That has a recommended range of 7 to 9, and it was accepted that all pHs in that range were obvious. And in fact, 8 bang in the middle was the most obvious. And he identified the arguments advanced by DSM in a passage starting at 869. And my friend suggests this was all just cut and paste from our closings. Of course, it is closely based on the language of those documents, no doubt to ensure that he couldn't have been said to mischaracterise the submissions. But it's not fair to say this is just cut and paste. We can see, for example, the judge set out what each party contended with language such as Mara referred to, see paragraph 855, on that basis Mara submitted, paragraph 859, and so on. And it's the same for DSM's contentions, where the judge also included his own conclusions and reasons for them as he went. See, for example, paragraph 871. Now, my lords know that at the end of the section, there's a short bit of the judgment where the judge concludes that the claims in issue were invalid and accepts the Mara contentions he set out in paragraphs 852 to 868. And in my submission, it's clear that at that point in the judgment, the judge is relying on both his acceptance of those contentions and the reasons he'd previously set out, not just that at 877, referring to the construction, but for instance, what we've just seen, a conclusion that he made as he was going through DSM's contentions, for example, 871, 872. Of course, when the judge's wording is subjected to intense scrutiny now, we can see it could well have been better to have the sentence accepting the earlier submissions before the sentence stating for all these reasons. But that might well have been misunderstood as not including the reasons the judge has also given earlier in, for instance, the DSM contention section. We can't know for sure that that's what the judge thought. What I do say is it is clear the substance of what he's doing is relying upon both the reasons given as he went through DSM's points and the contentions and reasons he's recorded as advanced by us earlier in paragraph 852 to 867. And it's not right to suggest the judge gave no reasons or only gave that given in paragraph 877, or that he failed to engage in any analysis. My friend rightly recognised that the judge might, in a contingent section of a judgment, deal with matters more briefly. But the substance of what he did wasn't particularly brief in any event. What would my friend's complaint be if the judge had, at the end of each of the paragraphs of substance in 852 to 868, said he agreed or accepted the submission? There could be no complaint at all. And that is the substance of what he's done. It's no different. Now, my lords know the key paragraph in these two sections for this appeal is 864 on page 302. And that refers to the common general knowledge and paragraphs 27 to 30 of COBSEF and some evidence of Mr. Dweppen. And we can see those paragraphs in COBSEF at Supplementary Bundle tab 4, page 134. It's part of the detailed description of the invention in COBSEF, but prior to a specific detailed example. And what these paragraphs are doing is addressing generally the step of separating the lipid from the broth. So that's subsequent to treating with the protease. You can see it follows on from 26, referring to the protease treatment. And the paragraphs are a bit repetitive, but we can see paragraph 27 says in brackets, it may be an emulsion. 28 then says it may require additional treatment with, and then lists a few options, including polar organic solvent. So that would cover isopropanol, but others are included. Key to note are salt and heating. And I've just mentioned in passing, draw attention to the fact that it's not only indicating treatment if it's required, what the treatments can be, other than polar solvent, but it's also suggesting the need for additional treatment at all is not universal, simply that it may be required in some cases. And one gets a flavour of that if you just jump to the opposite page and look at the beginning of paragraph 36. It says right at the start, in some cases the lipid can be separated directly from the undesired materials, such as by centrifugation or other appropriate methods. My lords, the passage as set out in paragraph 36 of COBSEV and the evidence relating to it was dealt with by the judge in paragraphs 825 and 827 on pages 297 and 298 of the core bundle. And key to this is the acceptance of my friend's expert that this includes disclosure of separation of lipids directly with no solvent of any sort involved. So you've got three different things that Mr. Dweppen agreed was being disclosed. And reverting back to paragraphs 27 to 28 and picking it up at 29 in COBSEV itself, so in the supplementary bundle 134, that remarks that if it's an emulsion, the product could be treated, could be used as is or dried, as my friend identified yesterday, or treated to release the emulsion. And paragraph 30 covers what the treatment can include. And of course, we see it can include treatment with a polar solvent or salt and so on. So the upshot is additional treatment may or may not be necessary, but if it is, it need not be a solvent. And obviously, my lords see immediately what is most definitely not saying is that you must be using organic solvent. You can do that, but it can be one of the others, or perhaps a combination of the others. And the point raised by my friend's appeal is a suggestion that the judge was not entitled to hold that one of the obvious things to do following COBSEV was to proceed with one or more of these other methods rather than the polar solvent. And my lords will recall that in paragraph 864, that one that is the key one we're arguing about, referred to the CGK and these paragraphs in COBSEV. And as to the CGK, I'd remind my lords that the use of salt was CGK, seeking to break an emulsion. We deal with that and give my lords the reference in paragraph 39C of our skeleton, page 11 of the document. And heating was CGK, which we do the same for at subparagraph D. Before we look at the key bit of the transcript, the final matter we draw my lord's attention to is right at the foot of page 11 of our skeleton, the fact that COBSEV itself also suggests that using a protease to lyse the cells can help with breaking the emulsion. That's paragraph 16 of COBSEV. My Lords will see that at page 133 of the supplementary bundle, left-hand side, by the bottom hole. And that's something my friend's expert said would be trusted to be correct. We give my Lords the judgment reference for that in subparagraph 39E of our skeleton. So, my Lords, just pausing here, what we have is COBZEF itself, specifically emphasising the impact of protease on an emulsion. If it were to form, its breaking would be aided by the protease. We have COBZEF also plainly contemplating that additional treatment to deal with an emulsion may or may not be needed, and that if it is needed, it may, but not must, include use of a polar solvent. Could equally be treated by other methods identified, including 2 CGK methods of salt and heating. And that brings me to the cross-examination that my friends say the judge was not entitled to rely upon. And for that, my Lords need the second supplementary bundle. Tab 16. The last page of this is tab 45. Last page of the tab, page 454. And the manuscript, pages 296 to 299 on that page. And before we get into it, my Lords may or may not be aware that just last week we had transcript corrections, not to the evidence here, but elsewhere. But what it did do was throw the line numbers out a little. I believe that in our skeletons they've been updated to reflect it, but the judgment will include references that are slightly out because of that. And I think here it's out by 3. But that's why that is, so don't be worried too much about that. The judge identified the passage in his paragraph 864 as line 8, 296 to line 20. But that means we need to look at line 11 down to 23. Actually, before we get into the detail of what was said here, can I address a further point my friend sought to make yesterday about other parts of the cross-examination transcript? He sought to make some argument that really if a point on obviousness was put, it would have been put elsewhere, and took you to other parts of the transcript where I was addressing the disclosure of COBZEF with Mr. Dweppen. My Lords, my submission is that's a very bad point. Perhaps it's just me, I don't think it is, but typically my cross-examination will be structured to do the disclosure of a document, perhaps including technical consequences first, and to address obviousness separately once the totality of the disclosure has been gone through. I don't try to do it on the fly when first tackling individual paragraphs. So there's nothing in the point to say, oh, look here, Mr. Speck's asking him about that paragraph and he didn't suggest some point on obviousness. What matters is the bit that the judge relied upon and I rely upon. Now, turning to my friend's big point from the key passage, he now says, in substance, this cross-examination is not on the basis that a polar solvent is not being used, and he's inviting you to read it like that. But what my Lords see here is me questioning Mr. Dupin on paragraph 30, after just having an agreement that it would be of interest if there was an emulsion. And actually, just to put you in context, you see at the bottom of 295, we've narrowed it down to talking about the possibility of no solvent or free Alex, because you don't get an emulsion with the hexane type of scenario. So we've narrowed it down to saying that that's two of the 3 scenarios that COBZEF itself discloses what we're considering here. And that's where an emulsion may be an issue, which he also agreed. And the first thing we talked about in the extract that my lords are looking at is that one method identified to deal with it is polar solvents. But then at line 19 on page 296, I pointed out there are other techniques. He agreed. The first one I raise is salts. This is line 21. He agrees at line 22. At line 23 to 25, he specifically agrees it could break an emulsion. I then focus his attention on the para 36 scenario without, para 36 being Kobzev, without a polar solvent. And I specifically refer to it using direct separation such as centrifugation. He agrees it was centrifugation without using alcohol or other polar organic solvent. That's line 7 to 12. At line 13 to 18, I remind him of the fact that adding salt operates such that the centrifugation has an amplified difference in density. And the crunch question is that using salt was one of the obvious things to do. Now, just pausing here, that hits the claim on my friend's construction. pH is at 8 or above because that's the obvious pH to operate the protease at. And integer C is present by use of the salt. And my friend is seeking to undo that by disconnecting the question and answer on salt from the questions before. And my submission is this was all of a piece. We were plainly talking about a scenario where one is centrifuging without a polar solvent. And when doing that, adding salt was obvious. And that was certainly what the judge understood was being considered by the witness. And my submission is it's certainly not for this court to interfere with that. I should deal with the rest of the passage because my friend relied upon it, at least in front of the judge on the minute of order hearing, and also in his skeleton, although not so much orally. But back in the transcript at page 297 of the manuscript, I moved on in lines 19 to 23 and put the skilled person would know other techniques in para 30 could also be used. He agrees heating is another obvious thing to do. And my lord, just at that point, that's the end of the passage we relied upon in our submission to hit claim 1, which was accepted by the judge. In fact, the passage went on to focus on the scenario where both salt and heating was used, and specifically the order one might do the two in. It doesn't matter for my lords, but the point was that claim 6A, which was said to be independently valid before the judge, specified heating to be done after adding the salt, although it didn't identify a particular advantage. So that's why I was exploring that. The guts of the point I was putting was that doing it in either order is obvious. He said he didn't know if one order or the other would make a difference. And it ends with him saying, this is lines 10 to 13, you'd have to test it to see if order did matter. As I say, it mattered for claim 6, not resurrected. Indeed, my friend doesn't appeal the judge's acceptance of the analysis we put before him on 6A. That's paragraph 866 of the judgment. We submitted salt and heating in either order is obvious, and our argument went on to address the evidence at the end of that paragraph. It was then page 297, line 21, to lines 298. Been knocked out 3. In fact, there's a typo in the judgment. 291 should read 297, but that's the evidence that just reads on. And there's no appeal from the acceptance of that. And that's significant because this evidence is actually directed to claim 6A, and my friends are saying to say somehow it vitiates the answers we extracted earlier on. It didn't even do to defeat the obviousness point on the claim which it was relevant to, and they don't appeal it. Now, let me address the detail of my friend's attack as briefly as I can. My lords know that my friends attempted to undo this finding below, and the first thing they did was to suggest the judge hadn't meant to accept that it was obvious to proceed without using polar organic solvent. We address this in paragraph 37 of our skeleton and give my lords the reference where you can see it in the transcript. I don't ask you to turn it up now, but if you do, at the end of page 122 of that transcript, you will see that at the time my friend's way of dealing with this point was to suggest the witness was talking about mayonnaise or salad dressing in his head when he gave the answers we rely upon, and that's hopeless. The next thing to mention is that in the form of order judgment, the judge explained why he'd refused permission on 801, and doing so he explained he'd revisited the transcript given the suggestion there was no evidence at all on the point. And that's the last tab of the second supplementary bundle, tab 25, page 516, paras 1, 2, 3 and 1, 2, 4. And he explained, this is now 124, that when faced with their argument, he went back and carefully reviewed this section, the main judgment, in particular the transcript references they'd relied upon. Their point at that point was read on. He notes he was proceeding upon the basis in case he was wrong on any of the construction issues that were live before him or on the disclosure of Kobzef. And he expressly says the transcript reference in 864 appears to him to be correct. And that's so even if you read on to include the bit that I've just shown my lords that my friend was anxious to be included. And the nub of what he's saying at the end of 124 was this is his evaluative assessment, having heard Mr. Dweppen give evidence. So, my lords, he did it once in preparing the judgment, and having heard DSM's argument, he went back and carefully reviewed it again, checked the transcript as far down as they suggested it should be read, and he's confirming it's his conclusion. I'm not going to ask you to turn it up, but he summarised, in effect, that in his form N460. So that is his view, specifically, the reasons that we advance, which he accepted, included reliance upon that transcript reference, which we've heard the witness, which he, having heard the witness give evidence, he considered was correctly characterised in paragraph 864. That it was obvious to use salt and or heat without polar organic solvent. And he's right about that. And my submission is this court is certainly not in a position to say he wasn't right. Now, the detail of how my friend develops his argument, at least in his skeleton, boils down to 4 points, which we see in their skeleton from 71 to 76, which we answer in our paragraph 42 through its subparagraph. The first contention is that there was no evidence to support the conclusion. And that's where, at least in the skeleton, he invites extended reading down to the end of the passage that we've just been looking at. But as I've explained, particularly that answer where he agrees using salt is obvious, that's enough to hit the claim. And he also agrees heating is another obvious thing. That also would hit the claim, but I only need the salt. And it was plainly open to the judge hearing the evidence to conclude that that evidence was to the effect that using salt in the absence of a polar solvent was obvious. And what the witness says in response to a question directed to the ordering of techniques doesn't undo that. I go further, actually, and draw attention to the fact that the witness really appears there to be directing his answers to knowing something will work when he says, I'd need to test it. Something can be perfectly obvious before one has confirmed it. And indeed he accepted that the use of salt was obvious. My friend's second point is really an attempt to re-argue the point, suggesting the judge was bound to conclude claim 1A was not obvious. Do please note the way it's put in his skeleton, paragraph 73, line 2, bound to, and he has to do that. The substance of the contention is no reasonable judge could have come to the judge's conclusion. And what my friend then does is set out a series of sub-paragraphs. The starting point is to allege that COBSEF doesn't disclose the combination of solventless process using salt or heat. Well, we've seen it does disclose the 3 scenarios the judge set out in paragraph 827. Separation without any solvent, the Free-Elex type technique, and the use of a solvent to solubilize, such as the hexane type scenario. And it does identify techniques that may be used to break an emulsion if it forms, as we've seen, including heat and salt in addition to the polar solvents such as Free-Elex. So, my lords, it's obviously right to say there's no detailed specific example, which is scenario 1 of paragraph 827 of the judgment, using no solvent at all, where an emulsion was dealt with by salt or heating. But in my submission, that's not a very fair overview of what COBSEF is disclosing, particularly as the thrust of what my friend is seeking to argue, is that there will always be an emulsion. The first paragraph 827 scenario, no solvent being used at all, so no Free-Elex, is disclosed. Also disclosed are ways of dealing with an emulsion which may form, including the 2 CGK ways, salt and heating. It tells you to look to those if treatment is needed. My lords, my friend's next paragraph, 73b, is rather extraordinary. It argues that it was CGK, salt and heat to aid breaking some kinds of emulsions. However, no evidence that it was effective on any scale for microbial oil extraction. I think this is my friend's, perhaps it was known for mayonnaise or salad dressing, but nothing to do with our field point. And he says here, on any scale. And what he's doing there is recognising the judgment's distinction that what was done on a small scale in a lab, in industry or in academia was not necessarily the same as the commercial scale activities. My friend says Mr. Dwaypen was asked about known ways to break an emulsion at the priority date and didn't agree it could be done without a solvent. And he relies upon the transcript at day 2, line 2, page 206, line 20 to 210, line 2. Before we go there, of course, all this ignores the fact the judge held salt and heating was CGK in this field, and most importantly, that COBSEF itself explains the emulsion issue is in fact aided by the use of protease, and moreover suggests not only that one might not need a treatment, but if you did, it identifies the CGK salt and heating techniques to be used if there was an emulsion. So it ignores all of that, but in any event, in my submission, it's not a fair reflection of the passage of evidence. A fairer way to put it would be that when challenged to consider smaller scale 2, he maintained that it could be done, but not easily. He did not say it could not be done. Let me show you that. Supplementary to tab 16, page 438 of the bundle. page 206 is top right hand of the page. My friend picks it up at line 20. I would suggest you look at line 14 because you see I refer to totally aqueous, and that's how the label we used about at trial about no solvent at all. So no hexane nor freelex type thing. And the point I challenge him on first is that the evidence is directed to commercial scale. That's line 20. His response was that was what his work was directed to. But emulsions formed on a small scale too. That's page 207, line 5. I suggest they could be broken, line 8. Answer, not easily, but it could be done. Answer at line 11, it could be done. Again, not easily. I moved back. This is line 13 to address the fact that his written evidence was directed to a commercial scale. He agreed, yes, at line 18. I'll just interject, you may recall that the judge drew particular attention to the fact that they hadn't addressed smaller scale lab usages in their evidence. And he went on to say, still difficult on a small scale, but not added to his report. He repeats this emulsion is difficult to break at line 6 on page 208. And then I talk him through specific documents. So now, I'm not talking about generally, I'm talking about specific documents, typically from DSM itself, where on each specific detail, he said for that example, in effect, he didn't believe it. See, for example, the question and answers at the foot of page 208. And I think the question, what my friend particularly relies upon is a question specifically on bile that I referred to at the foot of page 209. This is line 18. He repeats he's sceptical at line 20. And I ask him to agree by 2002 and 2011 there would be no issue in doing it on a lab scale or pilot scale. He suggests they could have used a polar solvent, which is of course not what bile is saying, which could mean it would not be truly solventless. My friend stops at line 2 of page 210. It's worth seeing the passage on small scale actually continues down to line 9, where we turn to discuss commercial scale. And in those extra 7 lines I put to him salt, and he says it was a known potential emulsion breaker. Now, my lords, this evidence as a whole is not fairly read as saying there was no known way to break an emulsion without a solvent at small scale. It's Mr. Dweppen saying it could be done, but it was difficult. And as regards specific descriptions, particularly bile, him saying he didn't believe them as to what had been specifically described. In any event, as I've said to my lords, just looking at that ignores all those matters that I drew my lord's attention to as to what the judge actually held. Now, my lords, my friend's next paragraph is sub C of para 73 to revert to Mr. Dweppen's written evidence, and he identifies the bit set out in the judgment at paragraph 875. This is where he suggests that he didn't believe it would be obvious to arrive at the method of 801 from Kobzef. And what I say about that is it's not a very promising submission. In every case, each side has written evidence from their experts to that or the opposite effect. And in this case, we know they focused only on large-scale implementations anyway. My friend's argument then proceeds at para 73D to the cross-examination, which is obviously what really matters. And he's obviously already touched on this in his first submission, where he says there's no evidence to support the judge's conclusion. And in fact, we will see when we get to the end, paragraph 74, it's really just the same point. It's the first submission being reworked in my submission. There is evidence in the cross-examination. We've been through it. Now, turning to the detailed sub-paragraphs in his paragraph 73D, here we see an argument that, in effect, my case was that Kobzef inspires the skilled team to see whether a solventless process could be developed. That's his first sub-paragraph. He says, I just assumed it as an example of hindsight My lords, just pausing there, it is simply one of the three scenarios COBSEF itself expressly identifies. It's not a case of a disclosure being used to inspire anything. It's written there. And it's that which I was expressly asking about. It's that which the judge identified as one of the three things disclosed in paragraph 827. My friend's criticism continues. He asserts Mr. Dwepen's evidence wasn't that an experimental design would be needed, as if it was not known if the techniques would work. From there, my friend argues there was no reasonable expectation of success. Well, in my submission, that's a bit of a non sequitur. Not knowing for sure something doesn't work doesn't mean there's no reasonable expectation. And in any event, I think, as my friend accepts, expectation is only a factor in cases, and how great a weight one puts on it is depending on the circumstances. And here, the document itself is telling you to use salt. My lords, another point that my friend made is to suggest that I was flitting backwards and forwards between para 36 and para 27 to 30, selecting from these passages specific techniques, omitting what my friend says is the one thing the skilled team would know was necessary to break an emulsion, and he says it reeks of hindsight. Now let me just pause and meet that point head on because it's important. The first option in paragraph 36 necessitates no solvent. I'm not flitting back to paragraphs 27 and 30 and making a choice to omit a solvent at that point. When looking at those paragraphs, use of a solvent is the other two paragraph 36 scenarios. The second is Freelex and the third is hexane. All I'm doing is pointing to the fact that where the document itself identifies scenario 1, that means no solvent is used, and it also, in paragraphs 27 to 30, gives you techniques that can be used within that scenario. My lord, the final contention is that at no stage did I ever put to Mr. Dwepen that the whole line of reasoning would occur to the unimaginative skilled team without hindsight. My lord, this is not a case of anything having to occur to them. It's written in COBSEF, as I've just explained to my lords. It's worth recalling that COBSEF was an anticipation attack too, and my friends escaped that by the skin of his teeth for the reason that the flag was not planted on pH 8 or above. That was the only point. My lords see that in the judge's paragraph 850, where he expressly states that the other elements of the claim are all there, and there's no appeal from that. Have I got that wrong?
Yeah.
My friend says there is an appeal from that.
Round 1A.
If
Round 1A is an appeal.
the anticipation. In any event, whether there's an appeal from it or not, that was the judge's conclusion. It's all there. pH, the thing missing for anticipation, is obviously nothing to do with what we're arguing here. And I made that missing step good on obviousness because COBSEF says 5 to 9. But on obviousness, the actual choice of the pH comes from the alkalize enzyme. which is to be used at pH 7 to 9. All of those are obvious, 8 the most obvious. And there really is no more to it than Kobzev's scenario 1, expressly identified, necessarily doesn't use a solvent. And an obvious way to do it is by using salt, as Mr. Dweppen agreed, or to use his language, did not disagree. Well, there's a few more things in my note, but I think I'm just getting repetitive and doing it to death. It was well within the judge's entitlement to conclude that the evidence was to the effect that he did, and that is, together with the other findings he made, meant that the finding of obviousness is well open to the judge in my submission. Are there any questions that you have for me on that particular aspect of the case before I address the infringement?
No, thank you very much.
So the infringement points to pure point of construction, as my lords appreciate. It only arises if the validity appeal succeeds, and the construction of the words in the claim of raising the pH to 8 or above is what matters. And my friend's contention here is that there is a standard rounding convention recognised in the authorities. They say that when comparing two numbers, it may be necessary to round one to the same degree of precision as the other. That's my friend's paragraph 43. And they like to refer to it as the normal rounding convention because the convention in that was referred to as that. But I want my lords to understand at the absolute basics at the beginning. What we're referring to is no more than what a skilled reader would understand as covered or meant by the language. That is absolutely key, and I don't understand my friend's submission to be any different. And where numbers are used in a technical or scientific context, they may, depending on context, be understood as rounded to a particular degree of precision, meaning they actually extend to values which round to the same degree of precision. And the question here is whether the context indicates that or not so. And there are a couple of points that I really want my lords to have in mind from the outset. First, where a range is given, that is different to a single value. And just to be clear, a range, what I mean by range is that it can have numerical bounds at both ends or just one. Like both are ranges, they're just different ways of having a range. And the reason they're different is that the numbers there are identifying a boundary when you move into or out of the range, whichever way you're going. Rather than something which, if it was a single value, certainly if it's a scientific thing, you would know, as I'll explain, you're never going to actually be able to hit it bang on. But a range is identifying a boundary, so it's different to a single value. And as a practical matter, the limit to a range can mean...
I don't understand that point.
Right.
A single number has two boundaries, above it and below it.
But the width of what hits it is infinitesimally small.
Well,
I'll come on.
That depends on the degree of precision to which that number is expressed.
Indeed, and that's why a single number would often be understood as requiring some width. And I'm going to come on and address that because the judge did deal with a single number. But what it is important that my lord does understand it, so I'll try again. A single number, if you realise nothing is ever precisely at a value which is infinitesimally small, narrow, a single number is practically harder to understand as not including a width to a boundary. A boundary is just the point at which you move from outside the range to inside the range. And actually you can understand that here by, my friend wants 8 or above to mean 7.5 or above. That's what he wants it to mean. Both of those will do just as well as a precise identification of the boundary where you move from in the range to out the range. It doesn't need a width. In fact, the nature of what you're doing doesn't have any width at all, because it is the identification.
I don't understand the point here. The issue would be the same whether it said 8 or 8 or above.
No.
Because the question is, what does 8 mean?
Sure, but what matters is that you're dealing with something which is doing something different. And the very fact that the range has a width, I'm obviously not getting this across, 8 or above are different. They're different. And
to be sure, but the issue is the same, which is to what degree of precision is the numeral 8 expressed?
It also, well, actually there's an antecedent question, is whether or not 8 is intended to be something to which rounding is subject at all. And that's really what I'm trying to get at, my lord. If we'll see when we look at 8 or above in one of the paragraphs in the patent that it's accepted it can't mean 7.5. It just can't. My friend accepts that he's in trouble on paragraph 152 where you've got similar ranges. And the context of that is because of the other ranges means that it can't mean that, and it's not subject to any rounding at all. A range where you're just using a number to identify one end or other already has a width. The number isn't providing the width. The number is just telling you where the cutoff point is. The question is whether or not they meant 7.5 or 8. I understand that. But the point I'm trying to make to my lord is a range already has its width.
So you're saying, let's move on.
And that is part of the context of what we're doing, looking at what the purpose of these values are. And certainly the judge identified that ranges and single values were potentially different. Either way, the question is crucially dependent on context. Let me illustrate the point, perhaps. If the words were concerned with, say, a process that said, add at least 1 gram of a particular reagent. That's arranged with just one numerical boundary. Everything above it is included. Obviously, 1.1 grams fulfills it, as does 1.001 grams. But what about half a gram? 0.6 of a gram.
And if you have scales that only weigh to a precision of 1 gram, that may be material.
It may. I accept that.
Likewise, if the scales weigh to a precision of half a gram, different story. If the scales weigh to a precision of 0.1 or 0.1, different again.
I agree with my lord. Context dependent. Different story depending upon the context, not just as to the technology, but also as to the way in which these ranges are identified in the document generally. If there's some reason the skilled reader would understand from context that a disclosure to add 1 gram or more was to extend lower than 1 gram, it may well do. The crucial question is whether it would be understood as really meaning anything that would be rounded to 1 gram in a particular way. And let me be absolutely clear when I say rounded in a particular way, because you also need to know how to round it. if it is going to be rounded. So that also has to be part of what's understood, which is actually more than a degree of precision. And the point I make here is typically in science, if rounding is adopted, it's to a particular number of significant figures.
I would be astonished if you could point me to any scientific publication where there is not at least some degree of rounding. The problem is it's inherent in the use of numbers.
Yeah. I agree.
Because you cannot put in an infinite number of decimal places. So you are forced at some point to approximate in any number.
If you're using it as a single number, I totally understand. And the point I was on here, though, is a slightly more subtle point, my lord, than the way in which you round. And I know Miss Nizami is alert to this because she was very careful to tell you the nature of the rounding that she was after. Typically, you are rounding to a number of significant figures. So if it's two significant figures, 1, 2, 3 rounds to 120, 118 also rounds to 120. Similarly, 0.123 rounds to 0.12, but 0.126 rounds to 1.13. If it's one significant figure, it's different. You're going 7.3 goes to 7, 10.3 to 10, and so on. But take care, because 11.3 also rounds to 10, if we're talking about significant figures. That's not what they're asking for. Let me be absolutely clear. A different form of rounding is given to a number of decimal places. Sometimes it's used, but it is different. So to the nearest integer, or nearest whole number, if the number of decimal places is 0. So 10.3 would round to 10, 11.3 wouldn't round to 10, it would go to 11. Now, in this case, we're arguing about whether the proper construction of 8 and above is in fact defined as a cutoff point at 8 or 7.5. But in either case, we're actually meaning that precisely. If the proper construction is 8, then 7.99 is below and outside the claim. If the proper construction is 7.5, then 7.49 is below and outside the claim. So precision isn't everything, because both sides are actually contending for a construction which is being applied precisely. It's really about how the reader would understand these numbers are being used, whether they would be understood as defining the bottom of the range in this case, precisely, or whether it was actually intended to extend the range a little bit further below what's given as the bottom. Now, another important point on context here is that we are considering pHs. And there are several points that arise from that, because it's not the typical range, linear range of numbers. The first point that I make is it's a logarithmic scale. That means that what it is actually measuring, put simply hydrogen ion concentration, goes up by a factor of 10.
Now, at this point, I need to ask about the evidence, because what you say is certainly known to me. Whether it's sufficiently well known that the court can take judicial notice of, perhaps so, perhaps not, I don't know.
My friend says it's in the evidence, and I think
but that's what I'm asking about. Do we have evidence about?
I think it was even referred to in the judgment.
Right.
I'm afraid, stood here, I can't give you the reference, but it's common ground, my friend indicates, and it was touched on, to my recollection, before the judge. Mr. White says it's in the judgment, and we'll give you the reference. Just to complete my explanation, so as not to get too technical, but what that means is that 1 unit apart, what you're actually measuring goes up by a factor of 10. So there are 10 times the number of hydrogen ions in pH 4 than pH 5. And it's that way round, I'm afraid. It's a bit counterintuitive in that more hydrogen ions if you go down in pH. But it's 10 times more. And it doesn't have to be whole numbers. It's the same if comparing pH 4.3 against pH 5. 10 times more hydrogen ions. And what logarithmic scales also mean is that the midpoint is not halfway between the integer values. 4.5 does not mark the place where the hydrogen concentration is halfway between the hydrogen concentration at 4 and that at 5. My lords might remember logarithmic paper at school where you've got those lines which are not equally spaced, and that's the same thing. It means that going up halfway is not actually halfway along the scale. So you can't, the reason I'm drawing attention to this is you can't, with a logarithmic scale, just say I'm going to lump half of what falls between two values with the top value and half with the bottom and think you're taking the midpoint. You can't do that. That's what you do with a linear scale in the example, or the examples that I'm referring to. You look at a number and say, well, if I'm rounding 0.123 to two significant figures, it's closer to 0.12 than 0.13. So the convention is the bottom half of the gap goes up, and the bottom half goes down, and the top half goes up. The precise midpoint goes up as well. But we're not dealing with a scale like that when it's logarithmic. And a midpoint doesn't even mean a multiplier of a factor of half that. It doesn't mean a multiplier of 5. It's completely non-linear. The midpoint is in fact a factor of just over 3. It's a factor of square root of 10. There's another aspect of pH that I want to draw my lord's attention to. And that's that 7 is a cut-off point for both basic and acidic conditions, above and below respectively.
Well, to what degree are you expressing the number of precision? Are you expressing the number 7 when you say that?
I am meaning absolutely 7, which means
7.00000, and ad infinitum.
As a matter of theory, if somebody asks you how do I exclude anything that is not 7, then I have to do that.
Yeah.
To be clear to you, but that is what I mean. And what I mean is,
what that means is that, strictly speaking, 6.99 recurring is acid.
Yeah.
Take as many zeros as you like, add on a 1 at the end, and it's base.
Yes, and the point I think my lord's making to me is that you end up with numbers either side of the cutoff which are really, really, really close to it. But that's true on his construction and mine. It's not a point in favour of either of us. Whatever the construction here is, there is a precise cutoff and something with a 0.99 recurring just up to the bottom of it, or a 0.000, lots of zeros and a 1, is just the other side of it. That doesn't help the debate, my lord. The point I'm making about 7 is that it is understood technically as being where you move through from being acidic to alkaline or the other way. And that matters, because where you've got teaching that being alkaline is what you're after, and one of the boundaries, not the one that we're arguing about in the claim, but one of the ones included in the text with it talks about 7 or above, or 7 to some higher number, where 7 is a boundary is common ground. My friend deals with this and says it's an exception, but it's common ground that cannot be subject to rounding. You would not understand 7 and above as including 6.5 and above, because as my friend, as my lord just put to me, 6.5 is acidic. And my friend's answer, we'll get to it, my friend's answer is, well, there's a technical reason to do something different. At this stage, I'm just highlighting...
Except that I might say that in the real world of lab chemistry, if you've got 6.99 recurring, you'll treat that as being good enough for neutral. Even though, strictly speaking, it's faintly acidic.
Well, actually, my friend has to deal with 6.5, not 6.9 recurring. He has to deal with 6.5 because on his approach to 8 and above, 7.5 counts. So he then has to explain why 6.5 isn't good enough for 7 and above. So, and his answer is simply, yeah, you're right, but it's different. And at this stage, I'm not trying to engage those arguments. I was just trying to highlight the things about pH that matter, that give context. And the two things are the fact that it's logarithmic, so you can't just say the midpoint is halfway between, nor can you ignore the fact that at least one number, which is referred to as a boundary, actually couldn't conceivably be subject to this rounding. Now, before we move on, my lord, what that does show is that this number 7, a pH value, can be being used to mean precisely that, rather than one subject to being rounded down to 6.5. And the question for my lords on this point of construction is, when you look at all the absurdities that you get across each of the 3 paragraphs that have these things in, if you have rounding sometimes but not other times, would the context be that the skilled person would understand the words in the claim to be subject to rounding or not? And to be absolutely clear, the words in the claim are 8 or above, which appear in each of the 3 paragraphs where there are relevant lists of ranges.
What does the skilled reader do if they conclude, having read the document from beginning to end, that the authors of the document are not consistent in their approach to precision of numbers?
Well, that is in effect part of my friend's case, I think, because he actually accepts more than just 7. He accepts more than just 7 can't be subject to rounding. I think, if I recall correctly, he accepts that everything written in the fat paragraph, which is 155.
All right, let me rephrase my question, since you haven't answered it.
Well, sorry.
And it's fair, because maybe there was a premise in my question which was unexpressed, and therefore it's better to just take it in stages. So let's see what your case is. Is it your case that there is absolute consistency in this document as to precision of numbers?
Of numbers or of the target ranges that we're concerned with in the 3
numbers, numerals, precision thereof. Do you say that the document is absolutely consistent as to precision of numbers?
No, not at all. And I'm going to deal with the measurement point, if that's the point that my lord has.
So I think, therefore, it's common ground that the document is not consistent as to precision of numbers.
Well, with that,
and therefore that leads to the question which I did ask, which is, if that's common ground, what does the skilled reader do?
No, in my submission, there's a intermediate point, and that's that you would not understand the fact that measurements are given with different degrees of precision as in any way relevant to this. And that's something that, a distinction that was drawn by my friend's expert. And so when I accept what my lord put to me, you were putting to me a question at a level of generality which I do not accept is the right one, which is all numbers. You asked the question about all numbers, measurements and targets. Now, I will come on and develop that argument, but just so that you understand, the fact that I accept that numbers as a category, even within measurements. It depends on what the person measuring it measured it to. These are, when you've got measurements, it's not necessarily the choice of the author of the document as to what they put in. It's what they've been given as to the experiment that's been done. So I do say it's really important, and the judge accepted, not least because the distinction was drawn by my friend's expert, that there is a difference between a number that's being given as part of a target ranges in this case, and the degree of precision that you may see in a measurement, which may vary amongst measurements. So it's really important that my lords understand that I say that matters. Now, answering the question at the level of generality that I say is the right one, the targets, and I'm going to show you there are in fact 3 paragraphs. Both my friend and myself made a mistake in our skeleton in referring to just 2, because the other one's so much shorter. But there are 3 that are in similar form, setting out targets. Some of the lists are longer than the others. But when it comes to targets, my submission is, yes, they are consistent. And in each case, they mean precisely what they say. It is being given as a bookend or an end of a range as the precise point where you move from outside the range to inside the range. And I do reiterate something I just said to my lord a few minutes ago. At that point, it being used as a point where you move from one to the other, it really is not a point about precision, because it either means 7.5 or 8, such that 7.49 recurring is outside, or 7.99 recurring is outside. On either construction, something really, really, really close but not within it is not in it. Now, let me see where I ought to pick up my note, because I've been freewheeling for the last 10 minutes or so, trying to answer my friend, my lord's questions. Yes. Can I deal with a point that I've just mentioned? The distinction between a target and a measurement. That came from Mr. Dupin himself. And what we're concerned with is a target. And in fact, as I've already said, a borderline or a cut-off of the target to be hit. And we give, my lords, a couple of references to Mr.
Can you explain to me, how do you I mean, one can argue about the terminology of targets, because actually what we're talking about is limits in claims, but that may be a semantic difference. But how do you decide whether you're inside or outside the claim, otherwise than by a measurement?
You measure.
Exactly.
You measure.
So at the end of the day, it's all a question of what's the precision of the measurement.
No, my lord, because you can, let me deal with that head on. The measurement, you can see, for example, we saw yesterday, some measurements of pH are given to 2 decimal places in the patent. So we know at least that's possible. I don't think we have the kind of evidence that my lord was talking about the precision as to absolutely how far could you go. But if the measurement can be that...
The mere fact that measurements are stated to 2 decimal places doesn't tell you that they are accurate to 2 decimal places.
Well, it means that they've been measured and reported to 2 decimal places. I mean,
someone has read that off the scale. Doesn't mean it's accurate to that level of precision.
Well, if you're talking about statistics and errors on statistics, that's something different.
No, it's about the degree of precision of the measurement.
Sure. And my lord, the numbers are given to 2 decimal places in the patent.
Yes.
They may even be given to a greater degree on the instrument. Who knows? But, and this, I don't think my friend argues against this. You can tell the difference between, as a practical matter, when you're measuring between 7.5 and 8, because there is some processes where he accepts I'm outside the claim if it's 8, but inside if it's 7.5. That's the point of this argument. So this argument does not depend upon how precise can you even measure to see whether you're within the claim. We know that you can measure more precisely than the difference between the 2 points on construction. And that's a point in my favour. It is not about how precisely can you measure to know whether you're within the claim. I totally understand that if the examples that my lord gave me a little bit earlier about the 6.9999 recurring, the reality is you can't measure like that, so you're never going to be in a position like that, and you might, when you measure it, come up with 7. But it's not about that. There's absolutely no basis to start looking at this thinking that what this is about is how accurate can you measure to determine whether you're in the claim or not. It's what the words were intended to mean, whether rounded or not down by half a unit. And everybody knows that you can measure precisely enough to know that some of them will be in a different category of inside or out the range, depending upon what that construction is. So it's not about that, my lord. And just to be clear, I think I was in the middle of identifying that it was Mr. Dweppen that explained in his evidence, we give you the reference at paragraph 50 of our skeleton, it's paragraph 155 of his second report, that you shouldn't confuse pH measurements with targets. And he said it's not unusual for you to have measurements giving a greater degree of precision. And what that means, my lord, is that one would expect not to be able to look at instances where measurements are set out as inferring anything about how targets would be identified. And by how measurements are set out, I include individual measurements or, say, a statement that a measured pH was between X and Y because it's at a particular stage in a process and it's measured regularly. So that's the point that we make. There is a distinction between measurements and the degree of precision that you might expect or see. And that's got nothing to do with what you might expect or understand in terms of a target. And that was a distinction that Mr. Dweppen himself raised. Now, the real crux to this matter is that there are 3 paragraphs in 801 that relate to target values of pH. And as I've said a minute ago, we made the same mistake of overlooking the much shorter part 126. I don't think it actually matters because although that is the paragraph that relates most closely to the one in the claim, the thrust of the argument is the same. That these target ranges should be understood in the same way because they use exactly the same language. That's the argument on my side. The argument on the other side is, no, don't worry about the inconsistencies. Just treat them as exceptions. Now, can I just identify the paragraphs? So I'm in 801, so tab 2, supplementary bundle. And the paragraphs are 126, that actually, as my friend said yesterday, does, sorry, it's supplementary bundle, page 27. That does pertain to step B. And you can see that's a shorter list where you've got 8 or above, 9 or above, 10 or above, 11 or above, 12 or above. But we've also got 152. So that is on page 32, which also pertain to the target on add-in a base, but it's the second base, i.e. the option in step C. And the one that both of us also identified, turning back, supplementary bundle, page 25, you've got 115 in the middle of page 25. So those are the 3 key paragraphs in my submission, and that one relates to raising the pH when you're using a chemical method of lysing, as I think my friend indicated yesterday. Now, other reference to pH in the patent, for example, in the specific examples, is to measured values, either individual measurements or statements that measurements were between X and Y. And we say, for the reasons I've already given, they are to be contrasted, and in fact, Mr. Dweppen did that. And the judge was right in para 786, where he says looking to the measured values doesn't assist. And he could also have added the point that I made to my lord just a minute ago, that the precision to which you can measure definitely doesn't assist, because the difference between us isn't about that level of precision, it's about the difference between a half unit of pH. And the submission, the core submission that I make is that interpreting the target values in each of paragraphs 115, 126 and 152 have to be read consistently. We've set out 115 and 152 in our skeleton on page 17. And just to be absolutely clear so that you know, from my Lord's note, the ranges, the smaller list in paragraph 126 are also in both 115 and 126. And we say those ranges must be understood in the same way in each of these paragraphs. And in fact, there are some other ranges that are not in 126 that are in 115 and 152, so they have to be understood the same way. Some of those other ranges, for instance, if you look at 115 and 152 set out in our skeleton, you'll see both include the target range of 8 to 13. And my submission is that can't be sensibly understood to mean something different in paragraph 115 and 152, nor the very words we're concerned with, 8 or above, or the other instances of open-ended ranges, 9 or above and so forth, which are in both of 115 and 152 and 126. They must all be consistently interpreted in my submission. And why do I make that point? Well, I've been told I'm overseeing.
No, when do finish.
Why am I making that point? Well, there are several points that I'm going to make, but perhaps the one I can leave you with over the short adjournment is in 152, you can see some of the limits are already to a 0.5 value. So we have in paragraph 152, both the target raise the pH to 8.5 and above, or 9 and above. You've got both of them. Raising it to 9 or above does not mean raise it to 8.5 and above.
But you've also got 7.5 or above in the same paragraph.
Indeed. There are lots like that where I can make the same point, and I'm going to try to do it briefly, but I've got quite a few peculiarities that arise if you do rounding. And I think I've already foreshadowed. My friend's answer is ignore 152. It's different. I accept he's right on 152, but he's not right on the claim.
Is one of your points you can't round even infinitesimally below 7? Because it would no longer be a base.
Yeah, exactly. That is my point. That's why 7's different, but my friend also accepts 7's different. Actually, I'll deal with it when we come back, if I may, rather than...
Just as a matter of interest, how much longer do you think you'll be?
I've done quite a lot today. I've been a little bit longer than I was anticipating, I'm afraid.
Don't worry.
But probably 20 minutes.
Okay, thank you.
Perhaps a bit longer, but not.
Thank you very much. So, high plus 2.
All rise if able.